Chris, you're on such a roll. Let's bring you back and talk about examination of lay witnesses. I don't know about you, but I've never had a witness surprise me on the stand. Has that been your experience?
It's all such a surprise, and particularly from our own clients, which we should at least know what they are going to say, because we're always in touch with them, like daily, multiple times a day. And then they're on the stand and it's like, where is this coming from? So direct examination is such an important part. This is your storytelling. And it took me a long time, and I'm still struggling with it, to get direct down. Because, like I say, I came from criminal as a defense attorney. And so in criminal, the prosecutor would have always on direct a police officer or a witness. And they know how to do direct because that's pretty much all they do. The defendant never testifies or rarely testifies. So they're always on direct, and they have one question: what happened next? And so that's the way they would just go through chronological order all their witnesses. As a defense attorney, I'm not calling the police and I'm not calling the victims. I'm cross-examining those folks. So I got good at cross, very weak at direct. And what I found is that when I would put witnesses on in family law, I would just launch into this cross mode, and I would have very leading, suggestive questions. And it is a terrible, terrible thing to do. You are the conductor of the trial, but you're telling the story through these witnesses. It is their testimony that is evidence, not anything that you as the attorney say. So we got to get this information out. So when you call a witness, that person is on direct. And we know the rule, the cardinal rule, is that we cannot ask a leading question on direct, except for some special circumstances that we're going to get into. So what's leading? Leading is a question that suggests the answer. And that doesn't mean a yes or no. A yes or no question doesn't suggest the answer. It could be yes or it could be no. But a leading one is certainly going to suggest, like, this isn't true, isn't it? Or this is what happened, right? So we're suggesting, and we're asking the witness to adopt a yes or no to it, just like we would do on cross. Never, ever do that on leading. It is not effective. And here's an example. So say we're trying to prove that our client took some money out of a IRA or 401k account because the house was in default, and we're showing some necessity for that transaction. So a big old loaded question would be, did you cash out the retirement plan to save your house from foreclosure? Well, it's not leading, because it could mean the answer could be yes or no. But so say we load it all up on that. Did you cash out the retirement plan to save your house from foreclosure? Answer yes. There's a good chance the judge missed that. Judges are up there checking their email, buying stuff on Amazon, who knows what, and they may miss that. It went a bit too fast, and it's too many parts to that question. There's like 4 or 5 parts or more to it. And so the approach that I use on direct, and I figured this out when my kid was very young, and I was spoon feeding him, and I was like, oh, this is how you do direct. It's the little tiny piece of food on the little tiny baby spoon that's going to go right there. You're not going to get the big sub sandwich and say, here, eat this. But that's how we ask questions on direct poorly, is we give the witness the sub sandwich. So we want to break it down. So in the slides, and my eyesight's not so good, but you'll see it in there. It's called Doing It Right. I broke down the question here. Did you have a retirement account when you moved out of the house? Yeah, I did. Where was that held? Schwab. Did you take any money out of the account after you left? Yeah. How much did you take? $20,000. What did you do with the money? I used it to pay the mortgage on our house. Why did you do that? Because the loan was in default. So I now took 6 questions individually to, instead of asking that one big loaded one. And I think that's much more effective. And it could even be done better to get in there the stories about the how, what, when, why, where, all of those questions. Draw it out of the witness. Take your time. These trials are expensive. You brought the person in there, you got them on the stand. Everyone's expecting the show. Give them the show. Don't just rush through it. Let them tell their story. Now, there's sometimes when you can lead under the evidence code, and this is evidence code 767. There's comments to it. Sometimes, if it's a child witness, for example, and we have the child up there, or the witness is disabled, you can lead. If we're trying to lay a foundation for new topics, so we're transitioning. And like Robert mentioned, signposting, super important. Judges take notes. They want to, organize all this stuff, and you're jumping from custody to financial issues. No, they're going to get lost. So it's like, hey, now I want to talk to you about support. Or, hey, let's now transition into talking about your kids. That's a big old signpost to the judge and to the witness. Hey, we're changing topics. And so you can lead a little bit there to do that. To refresh recollection, you can go and do a little bit of leading there and saying, hey, do you see this document here? That kind of stuff, and go through there. And I think we're going to go through refreshing a bit. When there's a hostile witness, and that would maybe go on to the 776. And then certainly for an expert witness, we can just say, hey, just get right down to it, because they're not a lay witness. So there's sometimes we can lead under the evidence code. Why do we love to do it? Because we don't trust the witness is going to give us the answer that we want. It's not going to be the right answer. So we want to feed it to them and tell them how to testify. Sometimes the witness has a terrible memory or is just not bright. And we're saying, wow, I can't believe this. I went over this with you before in the hallway, and now you're telling me something totally different. So now we're basically telling them how to testify and them to say, yes, master. Or they're just talking too much and we have to rein them in. And so it's just like, hey, I need to focus you. This is what I want you to talk about. So that's why we really, really love to lead, but we do have to let go of that, because their words count. Our words don't. Let them tell the story. Leading is just allowing the lawyer to testify. It does nothing for the court. The court doesn't want to hear from us. They want to hear from the witness. And a yes answer on cross is very powerful. You're asking that question and they're admitting it. Their opponent admitting a fact that you put in there or asserted. That's very powerful stuff. On direct, a yes, not very powerful. Again, judge may not be paying attention. They're waiting for some action, and all of a sudden they look up and like, well, what's going on? So you want to get a story out there. You want those words happening. Sit on it. If you think it's powerful, ask another big open-ended question. Get them talking. It's just like you're going to watch a skilled interviewer like an Oprah. She's not going to just be like, hey, tell me your story. She's going to draw it out and ask a whole bunch of open questions. Now, with clients, this is the problem, because the clients are going to turn on you very quickly, and they could be the best or the worst part of our case. Many times the worst part of our case. It's amazing, but it happens. And so we've prepared them. Hopefully, if we've done our job, we've sat down and we said, this is what the courtroom looks like. This is the witness stand. This is what I'm going to be asking you. I have to ask you these type of open-ended questions. This is why I'm going to do that. This is the kind of questions I'm going to ask you. Here's my outline. But then it doesn't work well. And what I've learned earlier on, I would say, well, client, whatever happens, don't ever mention this. Don't ever say this. Well, what happens? The moment they get on there, they're nervous, and then they talk about that. So I don't do that anymore, but I will try and get them as comfortable as possible. We'll do some mock exams. And then we just have to let it go. We have to let them tell their story. But if the story is really bad, they don't know how to communicate, they're talking too much, they can't remember, they're totally nervous, we are going to have to go in there and take some control. If it's really, really bad, I would just call for a break. And remember, you have the power to do that. You can ask for that. Point of order, Your Honor, I need a little bit of time. And hopefully you can get that and let the client regroup because they got one shot at this. Now,
Chris, one thing I've learned over the years is anytime your client is on direct and, you're looking down at your notes and your client says, and furthermore, you need to immediately jump up and object that there is no question pending, because whatever is going to come out of their mouth is going to be absolutely devastating to their case. Like you say, it's something that they've wanted to say, and you've told them, no, you cannot say that. And the moment you're not looking, they're going to find a way to get that piece of very damaging information before the court. So, be prepared, because, they'll do it to you. You turn your head and not pay attention, and they'll do it to you. I guarantee it.
yeah, and some clients, and there are few of them, understand and have the judgment to be able to add one more thing in. But it's mostly true. Anytime they're like, "Hey, I want to add one more thing," it's like, no, 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 because we're in control of this, how this story is being told. So obviously, we got to know our facts. We got to know our client. We got to look at these cues. And that's where I don't take a lot of notes. I'm listening. And if I'm sitting there writing down everything, I mean, I got a court reporter here. I don't need to write this stuff down. So if I'm sitting there writing all this down, I'm losing the cues. I mean, if the client's complexion is, changing, they're freaking out, they're sweating, they're nervous, I need to listen to that. I need to read those cues and understand. And so how am I going to develop rapport? It's just like an initial interview with a client. You're not going to just go hit them with some hard stuff. You want to open them up. So maybe you start with stuff about the kids. People like talking about their kids. Maybe you start the examination there. Get them open up, get them comfortable talking about something that they know about and they're confident about before you hit them with the really hard stuff. Now, with lay witnesses, so this is a non-expert, not our client. We put up on the stand. It's a witness to something. These witnesses are super powerful because they don't have a stake in the litigation. So we want to really do a good job with these witnesses, and we're going to have them on direct. We want them to tell the story. So certainly one of the issues is on preparation, like how much preparation do you do? And I've struggled with this. So if you over prepare with them, then become familiar with them too much, and now they look like they're aligned with you. So now this powerful witness now looks like maybe has a bias. How many times you talked to Mr. Melcher? Okay, well, if it's too many conversations, then it looks too aligned with me. I've on the other side where I haven't had any contact at all. And I had one witness who was overseas. And so she had to testify remotely. And so I had talked to her on the phone, and she had a lot of good stuff to say, put her up on the stand, video wise. And then it's like, wow, none of this is helping me. This is totally like, I'm asking questions like pulling teeth. I'm not getting any of the story out there. What happened? I say no further questions. End of the day, call her up. I'm like, what happened? And she's like, oh, I thought you were the other side. I thought you were representing the other side. And it's like, no, I'm the good guy. You're supposed to talk to me. You're supposed to give me this story. So there was like not familiar enough. So you got to make sure like, hey, we're the good folks over here. This is what we're calling you in for. Sorry, it's inconvenience, but this is how this process looks like. Obviously, we want you to tell the truth. You can say whatever you want, but this is the kind of questions I'm going to ask.
There's one other point, and that is, another adage is never ask a question you don't know the answer to. And that, we normally think about that for cross-examination. But to me, it applies just as much for direct, because how do you know what your client is going to say or another witness is going to say on the stand when you ask a question if you've never asked it to them before? The one place you don't want to be surprised is to have a friendly witness put out something very damaging to your case because you never asked them the question before you put them on the stand. So remember, we all know that adage, but we think about it for cross exam, but it applies to direct as well.
Exactly. And that's knowing your case and prepare. I'm going to launch a little poll while we're doing this before our break about how many years in practice so we can see that. Now, um, Rob talked a lot about 776, and I have a slide in here. I think it's 87 or somewhere in there about a tiger, and there's a guy sitting there. He's about to bite the tiger's tail. And that's the way I look at 776. I'm not a fan of 776 because we're giving control potentially to the other side right at the beginning of our case. Because what happens in 776? We're taking them on basically on cross-examination. And if we're not too skilled at cross, we're going to ask open-ended questions. Well, why did you do this kind of stuff? Or maybe it's going to almost look like a deposition. We're going to ask all kinds of questions. We may not score a single point. What happens after that? No further questions on 776. Their lawyer then gets to examine that witness within the scope of the questions that you asked. And if you took it like a depo and you asked a big wide range of questions, there's going to be a whole wide range of questions that they get to ask, softball, right at the beginning of the case. Thank you very much. And I love it when other people do 776 on me because it's like, just watch, client. And I'll tell them, you may get called on 776 and you're up there. It's, yes, no, totally respectful, and just wait. We're going to take control. So be extraordinarily careful with that. If I was going to do a 776, it would be 4 questions, 5 max, very pinpointed, targeted. I absolutely know the answer to. They have to answer yes to that question because I have something to back it up to impeach them with it if they don't. So be very cautious. Could work, maybe not work. So what happens when you're caught leading? So you have your witness on the stand. You're trying to move through it. You maybe forgot about these rules and you led the witness, objection leading, sustained. That is the best thing that it can ever happen to you in a trial. That other attorney did you such a huge favor, basically just saying, hey, I think you're not doing such an effective job in your case. And I want to remind you that you need to do better on leading. That's what the objection leading means. And it's sustained. Now I get to redo it. A lot of lawyers freeze, run away. Oh my God, I don't know with leading what this means, and just go and ask the next question. That's not what the court's saying. The court's not saying moving along. The court's not saying I don't want to hear about it. The court's saying that the form of your question was wrong. And the other side is giving you the opportunity to do it right. So objection leading sustained is thank you very much. Now I'm going to do it right. And I'm not going to move through this quickly. I'm going to sit there on this and ask the what, why, how, when, where questions on it. What happened next? Why did you do it that way? Here's a great one for anything you get stuck. How did that make you feel? You get a lot of hearsay type stuff in with that one. And now, because they objected, you are now developing the evidence that you would have forgotten to do. So love it when they do that. The other maybe and last point on this topic is don't give up. And that's what I'm seeing is that when we ask a question, it's hard to frame this on the fly. You're getting all kinds of objections. A lot of people run away from that. Objection, sustained. Okay. That doesn't mean that we stop asking questions. We do not give up. If you want this evidence in, you need this evidence in, this is core part of your story, you will keep asking questions any which way you can until they drag you out of that courtroom. Don't give up. And it's frustrating because sometimes judges will say, I don't want to hear about this. I've heard enough. Well, maybe they have. If you already have it in evidence some other way, fine. But if they've never heard this, no, Your Honor, you have not heard this. And I don't want you ruling against me based on later on, 2 months later, when you write your decision, well, no evidence was placed on this issue. Well, yeah, because you blocked me from doing it. So I'm going to get confrontational with the court at that point, saying, you haven't heard this evidence. Where is this evidence? You are going to basically hear it in a very respectful way, of course. But don't give up. Ask it a different way. Take a break if you're fumbling, but you cannot let the court tell you not to put your evidence in. You can't let the other side's objections get in your way. Keep trying, go different ways, look at the evidence code, take these classes as much as you can, be a master at it, and take it as an opportunity. Don't get frustrated when your objections are sustained.
All right. Well, thank you very, very much, Chris.